So tonight's session, the introductory session, as we kind of call it, is more on preparing an effective cross-examination. Sorry, I'm fighting a bit of a cold. So we'll give you some initial tips and tricks and things that you might want to do to structure. Kyla and I, as each individual person has a different plan or a way of attack when we set up a cross-examination. So we're each going to speak for about 5 minutes about my own personal strategy. And then Kyla is going to speak about hers. And then we're going to get into 4 different types of cross-examinations. So cross-examining police officers, cross-examining complainants in a sex assault, what you do with a drugs case, and what you do with impaireds, I think was the other one. So as I said, I understand Kyla's got a PowerPoint. I'm sorry, I don't have anything. I have little notes. So you have to bear with me. I have no guides for this week. But I think from my perspective, the very first stage in any good cross-examination is really preparation. So what does that mean? That means from the moment you request disclosure, you get your initial disclosure, you need to read it with a very fine-tooth comb. Because within that, you're going to find little nuggets of information that may assist or pieces of information that you need to ask for as additional disclosure. For example, a complainant in a sex assault trial discloses that there were texts and Facebook messages, and leaving aside the issue of third-party records or conversations she had with other people when she disclosed the sex assault, that might not be in the initial disclosure, and you may have to ask it for additional. So once you get your initial disclosure, I get my initial, I get my additional, I get information that I need from my client. What does he know about the events? What's his background with the witness, etc. And then I've kind of got a structure. I've got a defense, and then every cross-examination that I do is geared towards finding or focusing on that defense. You need to also stay on top of whether there are third-party records or any other information that you might need to effectively prepare your cross-examination. What I do after that started, and when I go to actually prepare a cross-examination, the very first thing I do is I take a sheet of paper or I type it in a Word document, and I set out each and every time the witness is given evidence. So what I mean by that is this. So we've got Jean Smith, and Jean Smith is a witness, or she's a complainant, and she first spoke about the incident to her best friend a month ago. Then she spoke to a police officer. Then she gave a formal statement, like a written statement. Then she gave an audiovisual statement, and then she testified at the prelim, let's say, for example. So what I do is I put literally the number 1, the date, who the statement was with, and the source. So was it with PC Kettle, or was it audiovisually recorded with Detective Rogerson? And then I put the date and the length of those statements. And for me, why that's important is because when I get into the actual meat of preparing the cross-examination, which I'll speak about more in a moment, those statement numbers, so whether it's 1, it's 2, it's 3, it's 5, help me pinpoint my references when I'm drafting my cross-examination. And what I mean by that, you start to draft the cross, and you start with, I always use headings: background, how they met, how the relationship broke down, the night before the incident, if that's important, the incident, and then the incident might be subdivided into many other categories. And then what I will do, if there's a point that I want to draw out, for example, she says on one occasion the car was red, and then another statement she said that the car was black, I would put in there that at the end of the red, I would say 3/2. And just looking in that 3/2 tells my brain that that is the third statement, third page of the second statement. So the second number is always the statement or the source reference, and the third is the page. And then that way I know where I can easily find the information, because a good cross-examination, and what comes from this preparation, is really the control of your witness, right? You don't want them to stand in the hall or wonder about whether that's true or not. You'd be like, okay, if you don't remember, great, here's where it is, or that's what you said, and it was to this officer on this date and time. That confrontation and keeping the flow going and you in control is super important, which is why I kind of set it out the way that I do. Another tip, I like the headings. I like the points, I like the subjects, but don't stick too much to a script. It's a very active process of cross-examination, and you still need to be actively listening during the whole time, which is why that front-end preparation is so important. And then what I do when I get the evidence I want, the witness agrees with the suggestion I put to them, I just simply put a check mark beside the point, which saves me having to write notes. Because again, you lose a lot of that flow in writing notes. And if I don't get it, I put an X beside it. And if I decide to avoid the question, I put a strike through it. So at the end of the day, when I go back at the end of the trial or at the end of the court date and summarize my notes, I can look at it really quickly and know exactly what I got and what I didn't. The other thing I do within those headings or those notes is you'll find your own way, but I find a way to highlight contradictions. So the example I gave about car black, car red, I might bold them, I might highlight them in pink or highlight them in yellow. So when I quickly look at it, when I'm standing and cross-examining, I can see that it's a contradiction as between two statements, and I don't have to give much more thought into it that way. And then you get into your specifics of cross-examination. But I think for cross, the main thing is prep and source prep. And remember, it's not, I know I've referenced a lot of statements, but it's not only going to be statements that you're getting the source information from. It could be Facebook posts, it could be things that were told to friends, it could be something your client told you. So you need to be able to have those sources at the ready and multiple copies of them. We'll speak more about impeachment in another session if you want to contradict or confront your witness with that discrepancy. So in general, that's just kind of an overview of how I start my cross-examination preparation. And I think, yes.
Yes. All right, so you guys have to bear with me. My PowerPoint is kind of ugly, so I'm sorry, I'm not a beautiful PowerPoint person. This is basically out of my book, and of course I can't read it because I've got the thing on here. How do I make this go somewhere else? Okay, well, that's okay. So basically, I think it's always important to keep in mind when you're cross-examining why it's important to cross-examine, because if you understand the purpose of what you're doing, it's going to keep you on track rather than getting distracted by issues that might not be relevant to what you're about to cross-examine on. It might be really interesting to ask a witness about all sorts of things that have nothing to do with the case, but if you're not controlling the witness, directing them to where you want to go, and keeping in mind the purpose of your cross-examination, which is to compel the witness to answer in the way that's favorable to your case, then you are going to end up getting a little bit lost. So my method, I called it the Pinpoint Method in my book. Essentially, I start from the theory that if there's ever an opportunity to cross-examine a witness, you should take it. There's not value in leaving evidence unchallenged. And when you're looking at a trial, you're looking at, essentially, I characterize it like a blanket or a quilt that it's been knitted, and it's the picture of the case, and you want to pull at all the threads to make it all come apart, and cross-examination will do that. So in my PowerPoint, and I'll send this to Maya so it can be sent out to everybody after, I put a number of things that are reasons why you would want to cross-examine. I find it useful to think of the trial as not being linear and not being a narrative, because when I'm preparing my cross-examination, well, it's really easy to prepare in a linear way because that's how the case unfolded. It's actually better to prepare to ask the questions in a non-linear way for two reasons. One, for your own sanity, because when you're crafting your questions and you're planning your cross-examination, you want to be able to jump to a different issue without being stuck to this happened and then this happened and then this happened, like the Crown are usually with their direct examination. So you want to be able to shift gears, and that will actually get you psychologically prepared. If something comes up in trial that you're not anticipating, you're not tied to that sequence of events, and you can deal with it right away or deal with it when it's appropriate. So try and structure it in a way that's not linear. Even if you write it linearly and then change your structure around before you go into trial, it also keeps you from being really rigid, but it also keeps the witness on their toes, because your witness is thinking about the events in a linear way. That's how we recall events. And so if you're moving from event to event, it's going to shake them, and it's going to make it easier to challenge their evidence. So preparation is obviously key. I have a quote from Wigmore, the very famous quote about how cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of truth. And like Natasha said, the most important thing to a cross-examination and to preparing your cross-examination is knowing your file, knowing what each witness said, what each witness is expected to say, and using those details and being prepared with the questions and the notes and the references to set up the impeachment of the witness. So the way I do it is I create a list for every witness, good, bad, and omitted, kind of like good, bad, and ugly. Ugly is omitted. In the good column, I will make a list of every fact that the witness asserts in their statements that's beneficial to my client. So if the officer, I do a lot of impaireds, right? So if the officer says my client's balance is good, I'm going to put that in there because I want to confirm that on cross. That's good. I want to confirm that. And then in the bad, everything that's detrimental. He said my client's speech was slurred. I put that in there. I want to address that. I want to undermine that. I want to challenge that. And then in the omitted, things that are not mentioned. You know, maybe your client told you that they told the officer that they have false teeth. And the officer should know that that caused the slurred speech, but the officer left that out of their report. So you want to be able to put that to the officer. What did the officer or what did the witness leave out? And what are you going to make sure you challenge them on? And that's going to help you also remember to stick to the rule in Brown and Dunn, to always put your theory of the case and any fact that you want to get out to the witness. So the omitted column is just as important as the good and the bad. And so once you've created these charts, not only do you have this pattern, essentially like a sewing pattern, for where you're going to go with each witness, you've also got a master list that you can put in your trial binder right at the front that you can refer back to. And you can put in there, your page references for where you find it. So if you are like, I thought that this guy said that the speech was good, and you can flip, rather than flipping through the disclosure in the middle of trial and looking like you don't know your case, you can flip to your list, you can go speech, good, okay, I know where that is, and then you can go straight to it. And you look prepared, you look smart, the witness doesn't think that you're thrown off, and if you are. So good preparation also makes you look a lot more confident in court, which can help with the witness. Other things that I do when I'm preparing, I call up experts all the time. I phone them up, I email them on listservs that they're on. You don't have to retain them. Lots of them will just advise you about things without being retained. Like you can say, there was lactate in the blood results from the hospital. Does that have any significance? And they'll be like, oh yes, well, lactate can actually on the hospital analysis interfere with the results and provide falsely evidence for alcohol. And now you know that. And you don't need to hire an expert. You can get that out through the grounds expert if they're calling an expert. You can also join groups like the DUI-DLA or WiCCD to give you listserv resources. I recommend DUI-DLA for impaireds because there's a ton of experts on there who just share everything. I look at Google Maps Street View, and you can organize it by date. So you can go back to like June 2020 when this happened and see what the road looked like at the time, or the location, or the front of somebody's yard or house. Google Map the dates and time for travel distance. You can put the date and time that driving or an event took place into Google Maps, and it will give you the drive time from that specific date, as opposed to just a general, it takes 20 minutes to get here. It would have taken on June 1st, 2020, 16 minutes and 43 seconds, because they have all of that data they've collected and they still store. So it's super helpful to put that information to witnesses and to know that so that you can challenge them. You can also search court records for witnesses. I love to look up civil court filings because, especially in accident cases, usually my clients are being sued. But sometimes your witnesses are being sued. I once had a trial where the witness was being sued by his sister for a motor vehicle collision, and she alleged that he was drunk at the time of the collision. He was like devastated that I brought that up, and he's like, I didn't even know that was in there, and started crying. It was fun. Social media profiles. I stalk people on every social media channel. I'm looking my witnesses up on everything. I look at their profiles. I look for their likes. There's a really good TikTok account called Not Con Jr. who talks about how she finds people's birthdays, who ask her to find them on social media. And but she explains her process, and you can steal all of those things and use them to find detailed information about your witnesses through their social media connections. So even if they have a private profile, you can still get a lot of information about them that's useful. The other thing, remember, there's no property in a witness. So interview witnesses before trial. A lot of people don't do this. They don't pick up the phone and call witnesses. If you do this, though, make sure, like, ethically, that you have a legal assistant or an associate or somebody with you as the witness to the conversation, because if ever there needed to be sort of a challenge to what was said or how it took place, you would want to make sure that you're not stuck in a position where you're now the witness to the conversation. So you have somebody in the room with you. And do your own detective work. If the witness was another patron at a bar, for example, you can call the bar, you can talk to servers and managers to see if you can get more information from them. Maybe go to the bar, see who the regulars are, chat with the regulars if they remember that incident. Find out that information, because there is no property in a witness. And if you don't know everything that the witness is expected to say, can say, and could say, then you could end up failing in your cross-examination. I mean, probably not failing, but you might end up surprised by something, and you want to be prepared for everything. You want the witness to feel like nothing they can say can take you by surprise. And so it's an easy part to ask questions of somebody who's legally compelled to come and answer. But the hard part is knowing what to ask, how to ask it, and how to get the answer you want. And the best way to do that is through preparation. I also have some tips for how I organize my preparation. So you can either do this if you like to work electronically or paper. I'm a paper person. Sorry, trees. So I distill everything into a binder. I separate each witness by tabs, and then in each witness's tab, I put their statements in the order that they gave them. And then I also put the notes that I've made, the charts that I've made right at the beginning of their tab. And I have copies of anything that I intend to put to them, triplicate copies, one for you, one for the witness, one for the Crown. And one for the judge if necessary, if they ask to see it. Always put that in the tab for each witness so that you can pull it out right away. You're not flipping papers. And the witnesses also, as soon as they see you do it, like once or twice, the more paper they see, the more they worry that you have something else that you're going to confront them with. It's totally like a psychological game. It doesn't, sometimes you would just put a bunch of paper in there and it's not even stuff you're going to put to the witness. It's maybe like I had a folder this thick on like social media posts on a witness, and I took a few of them that were kind of bad and presented them to him. And he didn't want me to ask him about any of the rest of them. He basically caved on everything from that point on because he did not want me to pick up that folder and pull out some other racist thing he said on the internet, or some other, claim that he made about assaulting somebody. So it's helpful. So I do subtabs for all of those various pieces of information, and then put the master charts for each person right before the tab, and that way you have your quick reference guide. And that's my preparation part, so I will stop my screen sharing. There we go.
So then thanks, Kyla. I've got some tips from you too. I'm very paper heavy, unfortunately. I still like the good old fashioned paper and pen. But just to pick up on something you were saying, Kyla, I find there's real power. Like I do a lot of serious violent crimes. So I did a lot of homicides, attempted murders, guns, drugs, things like that, or, really bad egg assaults. And sometimes you're dealing with unsavory witnesses, or witnesses that are going to be a little, not unsavory, but slippery. And they have an agenda. They want your client to get convicted. They don't want to give you anything. Is the sky blue? They'd argue about whether the sky was blue. And they could be on the stand for hours. And the power of picking up the paper, like once you've done it a few times, and okay, so the transcript there, great. Could you go to page 32? And then you reading it out, and you do that a few times. It got, this summer in particular, it got to the point at the end where I would just reach for my papers. And they're like, you're right, you're right, you're right, you're right. I'm like, well, I don't want you to guess. Like, no, you're 100% right. Yeah, that's exactly what I said. Okay. And then you just the air. And once you get a little bit more experience, you get a little craftier. There were some things I hoped to get into the witness, but didn't think I could. And I just coyly kind of picked up the binder or the materials so they would think that I had something to contradict them with, even though I didn't. And I got the answer because I'd beaten them down so bad about all their other contradictions. So it works. It works really well. Okay, so what Kyla and I've done for the next section, ladies, is we wanted to talk about maybe some specific cases. So I'm going to start with drugs cases, because each case is going to be a little bit different in terms of your preparation. When I was giving you the example earlier, I think it's because I have a sex assault file next week for the whole week. So I think I've got sex assault in the brain about your complainant. But when you're dealing with a drugs case, it can be really different. And it depends, I guess, on the type of drugs case. You could have a hand-to-hand transaction or possession for the purpose of trafficking that relies on surveillance. So you could be, talking about fleeting observations or civilian witnesses, and a lot of that social media, which I also do, Kyla, you could do a little bit of deep digging on that. And don't underestimate social media for police officers. They're the best. They put everything out there. It's usually public, and there's a lot of good stuff that you can find in there. I had an officer once who was really, really racist. And my client was arrested in a small town, and he was Black. And he was traveling in through Toronto. And it was a racial profiling case. It's like, I would never do that. And I'm like, right, what you do, just set it up, right? Everybody's considered equal. You never say racist this, racist that. You go through it, right? No, I would never do that. Did you tell me why on Twitter on X date on this date you said that? You can set those things up really nicely, even with police officers. When you're dealing with a bigger drugs case, so let's say you've got an ITO, and there's surveillance and there's CIs and all sorts of information. There's even more prep that needs to go into those. And what I mean by that is when you have an ITO, the first thing you should be doing is you look at it and you review it and you go through it just like you did your other disclosure packages, and you go line by line. Because what you need to do in order to do an effective cross-examination, if you bring a Dawson, which is a cross-examination at a prelim, or if you're doing a Garofoli at a trial, is you want to be able to cross-examine that officer on the fact that he wasn't maybe being full or she wasn't being full, frank, and fair. So what you do is you say, okay, on X date, they surveilled him at this point. You put a line under it. You need disclosure of that surveillance report. You probably don't have it. Oh, I spoke to this person on this day. There's a call dispatch. Okay, I need that. Because you want everything, because you want to go back to the main document. And their main sources of contradictions are going to be in those I call them sourcing documents, the other source documents. And for example, he put in there that was actually in the sourcing document has that there were 3 people present, but your officer only tells the justice of the peace of the judge about 1, right? Is that being full, frank, or fair? So those are really, really nitpicky. And that's how you draft the cross in that case. It's literally point by point, source by source, all the way through. It's probably one of, except maybe a breath technician or an impaired, one of the most technical cross-examinations that you will ever do. It's just point by point by point by point. And I do what Kyla says as well. I don't go in chronological order. I mix it up. I set my cross out in chronological order, but I know my case so well by the time I'm standing up there that I could be talking about the background or the first section of the ITO. And the officer's like, yeah, but that wasn't really true because I also set out the car colors later on in the ITO. Oh, okay, you did. Let's skip to that. And you go, and then you show why it still wasn't full, frank, and fair. That's the goal of your questions. But you know that you have that coming up. But anytime you can flip, it really does knock them off their grounds. Another thing for preparing an effective cross-examination on a drugs case, leaving aside issues of ID, and that's a very valuable cross if it's a hand-to-hand, but dealing particularly with officers is they like to hide behind the umbrella of CIs. You need to push that a little bit. And what I mean by that is you write to the Crown and you ask for more information on the CIs. It's too redacted. They're going to tell you no. And then you need to push your officer a bit about the CIs as well on the stand. And they're, oh, CI privilege, you can't do that. But it's going to do 2 things. One, the judge is probably going to let you skirt around the edges of it. They're going to get you, if the ITO blocked off this information, the judge is going to let you pull in a little bit. And the second thing is you're going to make your officer really uncomfortable. And anytime that officer is really uncomfortable, things are going to slip or things are going to be said. The other thing with proper preparation on a drugs case, if you're dealing with an ITO or as a search warrant, we all know that when they come to us, they're heavily redacted. When a judge is assessing whether the warrant could have issued, they have to go off of the heavily redacted warrant as well. They don't get to look underneath the black portions. The judge sees what we see. But I've seen cases, and I've seen colleagues go through this, where the judge basically says, I want to see behind parts of it. And then you're able to see behind parts of it as well. Or he's like, it's too heavily redacted. I have to assume the validity of it, and the officer is being full, frank, and fair. And then what they've said is, you've never asked for more of it to be unredacted. So I commonly write to the Crown at the beginning and say, I want more of this unredacted. And I make them take a second fresh look at it. And then when I'm cross-examining the officer and he says, yeah, but there was this, or there was that, they're kind of stuck to the four corners of the redacted ITO, and you've covered off yourself and you've covered off your client. Yeah, anytime you're dealing with drugs officers, I always find them a little bit slippery. So preparation is 100% absolutely key. And get as much information as Kyla said, particularly drugs cases. Go see the drug house. Go see the rooming house that it was at. Take a look at the street view. The officers, and commonly the blackout locations of where they were conducted their surveillance from is an investigative technique. Push for that. And I tend to do prelims on big drugs cases, so I can set a lot of this out and have what I need for the even more thorough cross-examination at trial. But you want that, because you want to be able to go to that site and say, really, like, I can't see the front door bedroom window from here. You can only see this angle, and you can kind of try to undermine them and do that. And the more legwork you do on any type of case, but it's physical legwork on a drugs case, as well as very labor-intensive paperwork to get these through. And I hate to say it, but preparation is really, really key for these. And the more you're prepared for it, the better it's going to go. Over to you, Kyla.
Okay, back to my fun PowerPoint. So I am one of those really annoying people that I write a script for the vast majority of my cross-examination. I'm at the point now, though, where I write it just as my preparation. And I have like 10 questions in and my script is gone. But the act of writing it has been as important to me in preparing, in coming to know the file, in thinking through how the witnesses are going to answer the questions.
Hello?
That I still... Can you hear me?
What's this?
Oh, I think they're just not muted. Okay.
Okay, I'm still in court.
Can we mute that person, Maya?
I think we did. Yeah.
Okay, good.
I was like, hi. So the writing the script, the doing the work has been really helpful, especially with adverse witnesses. So dealing first with adverse witnesses, I always like to start in an area where I know I'm going to be able to gain control of the witness. Think about the common ground, all of those good things that you want them to confirm. Start there, because you're getting them comfortable with agreeing with answering yes, with being on your side. I also do this thing where, like, I will talk to the witnesses in the hallway, if they're men, or if maybe they're not straight, I'll flirt with them. That's really stupid, but it does work, especially with cops.
It totally works. Sorry, Natasha,
totally,
your 2 cents in it. I do it all the time.
Yeah. It's fine. It's worth it for my client. But also just talking to them. I'll talk to, like, I once sat with an officer and watched videos of iguanas that were coming back to life after really cold temperatures in Florida, and we just laughed over animal videos. And then he was like my friend, and he was much more agreeable on cross-examination because he felt an alliance with me. And I do that with civilians too. Like, there was a bodily harm case I had where the adverse witness, the complainant, she was talking about her injuries, and it was before she was still in direct, so I could talk to her. And I just told her about how I was in a car accident and how I had a really bad back injury and it was really hard for me. And we had this common ground moment. And then she was so agreeable in cross, when she was like a nightmare in direct for the Crown. So agreeable in cross because we connected, we bonded. So find your common ground with the witness, whether it's in the courtroom in the beginning of your cross or whether it's outside the courtroom. Make those inroads with those adverse witnesses, because if you can, you will get a lot further with them. It's like basically when you meet a new friend and you're trying to find out what you have in common. I also avoid at the beginning of the cross highlighting anything that's damaging to the witness. No gotcha stuff, nothing, no impeachment at the beginning. No information as well that I'm not 100% certain I'm going to get agreement on. I'm going to save all that for later because I don't want to betray their trust until the very end. Because once you betray their trust, then they're going to start to turn on you, and you want to already have control of them. You want to already have all that good stuff out and then betray their trust. And then because you've established such a significant rapport with this adverse witness, they are much more likely to react in a way that's going to hurt their own credibility and how they're giving their testimony at that point than they are to just be like, no, that's not what happened, if you do it too soon. And so that's generally psychologically better. I also structure my questions very specifically, like very much like the McCarthy, each question has one fact, and each fact should already be established from a previous question or based in the evidence. So you're just building one little thing at a time with these adverse witnesses, because if you put too many things to them, you can do this with experts, you can do this with lots of police witnesses. If you have them pinned to their statement, you can put a couple things to them at once. But if you have an adverse witness that's a civilian, especially, you want to do one thing at a time, even though it's slow. And I think I referred to Matt Dodd once did a seminar with me, and I called him a plotting lunatic in my book. We're friends. It's okay. He laughed. But you feel that way, but you are getting the yeses that you need, and you're building your one fact at a time until you get to what you want. And the witness hasn't realized that they basically walked into agreeing with everything. And I also end the questions with, is that right? Is that correct? So that they get trained into a pattern of just going, yes, yes, yes. And they stop listening sometimes. They'll just stop listening and they'll zone out and they'll just say yes, and they don't even realize they're agreeing with you anymore. Also use as few words as possible. The more words you throw in, the more they can disagree with. I also say don't ask questions where the answer could mean agreement if they say yes. So for example, if you say, there weren't clowns at the circus, and somebody says no, that could mean there weren't clowns at the circus, but it also could mean there were clowns at the circus. So you want to make sure your question is very, very clear. Don't give them any wiggle room to then later go, no, that's not what I meant. Your question wasn't clear to me. You want to be perfectly clear about each point. And I avoid all of these things. I put it to you that, we can agree that, you'll agree that, I suggest to you that, it's fair to say that. All of those things I view as broadcasting to those adverse witnesses that they should disagree with you. It's telling them, no, this lawyer is representing that person and they're on the opposite side as me, and I'm not going to agree with what they say, and we don't have common ground, and you're going to undermine the relationship building you've done if you start to structure your questions this way. I know a lot of people like the I put it to you that formula. That's okay with cops sometimes. I generally avoid it altogether. I think that it just broadcasts to the witness that you're about to suggest something to them that they should disagree with, because it's helpful to your case. Also, other phrases I avoid: claimed, I use instead of told the court, because claims are statements that could be false, whereas telling the court is testimony, which could be true. Told the prosecutor, I like to use that when asking them about things, because again, it undermines potentially the truthfulness of what they're saying subconsciously without alerting them to the fact that that is what I'm trying to do. And it also kind of suggests that there's some sort of special connection between the two that might undermine trust in the witness. Oh, you told the prosecutor this and you told the prosecutor that, and all you do is tell the prosecutor things, but you never put any of them in your statement. And okay, then we're into crossing police officers. So I will stop screen sharing.
That's good. And I just thought of something too. I like this back and forth that's making me think of things as well, Kyla. But in terms of those clear, and I agree, I avoid the in fairness, or you'd agree with me that, or keep it short and tight, because you don't want to alert them. But the other thing too, but the one fact based on evidence and building on that, you have to remember what the end goal is here. You want to get those answers to those questions, but you're also trying to convince your trier of fact at the end of the day. So you don't want there to be any ambiguity in your judge or your jury's mind as to what was said and why, right? You don't want a jury going back there, okay, she said there wasn't any clowns, but did she mean no that there weren't? Or yes, that there were. So you want it to be clear and concise. So the next kind of topic that we were going to talk about was sexual assault cases, or maybe even serious assaults as well. In terms of sex assaults, we all know that the landscape is very, very different. There are much fewer of those gotcha moments. Thank you, Gian Gomeshi, with the text messages, and Marie Hennon, who did an excellent job. But Parliament decided to change the rules for us and change the landscape, which now means the 276, 278 applications, because there's inherent expectation of privacy. So you need to kind of think about those early on and preparing your materials for that as well. But when I'm dealing with in a sex assault complaint, there's usually a main witness. You may have a few collateral witnesses that support your client's perspective of what happened at the party, or support the complainant's quick disclosure after the fact. But your main witness is going to be the complainant, and your main witness for you will be your client. And you have to prepare him for cross-examination as well. But when I'm dealing with a complainant, remember what I said at the beginning, I like to do that. Here's your topic, here's the date, the statement, the source, and everything else, and I have it all set out on my first page. And the next thing I always do, and it doesn't matter if they've given 2 statements, they've given 20 statements, I go through it, each one. Hopefully at this point I build up a bit of a rapport in the hallway with the witness. Works a bit better for me, having been called 20 years and practicing mostly in Ottawa and Brockville area. You get to know a lot of the officers quite well. How's the kids? How's the husband? You know, those things kind of come up. But you want to build a bit of that rapport. And everybody who comes to court, they're testifying, and they want the judge or the jury to believe what they're saying, right? So, you know, I set it up in I have a very structured banter. Okay, ma'am. The first time you gave a statement was on April 2nd, 2021. And that was to, yes, one fact, supported in evidence. And that was to this person. It was on this date, and it was about 4 pages handwritten. Yes, that's correct. Okay. And this incident had just happened. So it's fresh in your mind. The details are fresh. You know how serious this investigation was. You wanted to be truthful with the officers. No one made you feel rushed. You had all the time in the world to write out the statement. And you're being truthful as possible. So you go through that kind of banter, because what you're doing is also ingratiating yourself a little bit, and it's also building up a bit of a good rapport. I hear you. Serious thing that you went through. Had to talk to the police. That doesn't happen every day. You know, you're put in a quiet room and you're allowed to take your time. You didn't feel rushed. They supported you. Yes, of course they did. And then you're being truthful, right? Everything that you could remember at that moment. Yes, of course I was. Next statement, it's the police, same thing. You were in a child-friendly room. It was a soft room. There was a couch and tissues, and you didn't feel rushed. They gave you a glass of water. You were told you could leave at any point. You knew that my client had been charged at that point. You knew how serious it was, et cetera, et cetera. And you set all of those up, and you were telling the truth, because it's all about, yes, I had lots of time. It was fresh in my mind, and I was telling the truth. And it seems like you're just bolstering the witness. It seems like you're propping her up. Do like all of these things. You know, you fully participated. And then you spoke to the Crown. You had prep meetings, and he's a really nice guy, right? And in advance of coming to court, you met with the officer, and you had his email and phone number. You know, you could always reach out to him if you needed to. Really, you know, VWAP and all the support systems in the Crown, and you knew his email and all that. So that's great. Thank you so much. You know, and then you get through all of that. Never think a witness. Sorry, that was a slip of the tongue. And then you're like, all right, let's talk about the incident. And then you get into your cross-examination proper. And the reason why that's so important, particularly in a sex assault type case where it's a lot of credibility and reliability, that's always what it's going to come down to, especially in a WD when your client's going to testify. You know, small inconsistencies might make a huge impact. So when you get another half an hour or an hour into a cross-examination, and now she's not agreeing with you that she drank a 26er of vodka to herself over 2 hours. Oh, I had some to drink, but I wasn't that drunk. Well, no, it was a 26-ounce bottle of vodka in 2 hours. Oh, I didn't remember earlier when I was asking you questions, and I saved these for the end, right? Because this is that confrontation part. When you said that you were being truthful and honest, and that's the other thing, you reviewed it before coming to court, and there's nothing you wanted to change. And you knew if you wanted to change something, you could reach out to this nice Crown or this nice police officer, and you didn't do that. You're setting all of that up for those really big gotcha moments at the end that you really do need. Because in a sex assault, typically credibility, reliability, level of intoxication are going to be absolutely key. Maybe identification. Let's say it was at a party and you couldn't really say who it was. And that's when you get into that banter at the end and you're going back and forth between topics. You're doing those hard confrontations where you get to that point where you can just grab the binder of material. and she's complying, or she's agreeing even before you get there, that's what she said. It's unfortunate, anecdotally, that we now have to disclose all this material, and that the complainant's going to be alerted to some of the same materials, but it is what it is, and we have to work with what we have, which I think makes confrontation about other areas even more important within those statements and within the evidence itself. Okay, I think that's all I had to say about sex assaults.
All right. I'm gonna go back to my PowerPoint here. So last thing I'm going to talk about is cross-examining police officers. First thing I do, like very early on in my process with every police officer, I always ask them about their notes, because they're trained to take good notes. There's all that Supreme Court of Canada and all that, appellate level case law that talks about how their notes are so, so important. And the first thing I do, and this works like 90% of the time, is I ask them if they're trained to take their notes contemporaneously. Most police officers do not know that word. That word has too many syllables for police officers, and they stare at me. And I'm like, oh, do you not know that word? That means at the same time. We're like a little bit condescending about it, and it's super rude. But they feel so small and stupid, and it just knocks them down a peg right away. Because they come in, they got their gun, they got their badge, they're so important, and it just knocks them down right away. And it's like, this is just a completely normal lawyer word. The judge doesn't think it's a weird word. Nobody in the courtroom has not heard this word before except for the police officer, and usually they feel shaken by it. And then you get this really good control over them because they think you're smarter than them, and you might not be. I might not be smarter than most of the time, but they think I am because I used a big word. I also am nice about it, and I explain it to them, but I'm a little bit like, that little bit of condescending nice that women can do especially well. I do that. So the judge doesn't think I'm being mean. The judge is like, oh yes, she's just so nice explaining it to the witness. The witness feels usually emasculated, and the Crown doesn't know what to do. They didn't do anything about it. I also emphasize the importance of all of these things about the notes, that they take them contemporaneously. It's important to police work. And I do it it's like really important to police work. And they're, oh yes, that they are obligated to disclose it to the defense. And then I always throw in, after I say that, I say, and you always want to include things in your notes because you wouldn't want to be accused of omitting something from disclosure, right? They're never not going to agree with that. They always agree that they don't want to be accused of omitting something from disclosure, but right away their brain goes, what did I leave out? What is not in here? Because I know that something is coming. Even if I don't have anything, it throws them off because they start thinking about things that they didn't put in their notes that they should have put in their notes, and they get distracted and confused and scared. I also go through the procedure for writing like recall notes or later notes, late entries, sometimes they call them. I go through that procedure with them because inevitably in impaired files, they're writing their notes about their symptoms after they've made the arrest. And then when I can pin them to the fact that they needed to do it contemporaneously, I've had a lot of success in trial with judges saying this isn't reliable evidence because it might be something he came to believe that he saw as opposed to something he saw at the time. I avoid open-ended questions with the witness until the witness is perfectly trained to answer in my favor. And my favorite open-ended questions, I always add in open-ended questions. People say don't ask open-ended questions. If done right, they are incredibly powerful. If you ask them at a point in time where the witness can only say, or the officer can only say things that are going to help you, and they know that no matter what they say, they can hurt, they usually just spill their guts. So I'll go through like a number of their charter breaches with them, the things that they did wrong, that they didn't do according to their training. And then I'll say, Constable, what mistakes did you make in this case? And most of the time, the Crown doesn't know what to do. The officer starts to spill and tells me other things they screwed up that I maybe didn't even notice or didn't realize. Every once in a while, though, I get a judge who says, Miss Lee, if we had to have him answer that, we'd be here for the rest of the day. And then I know I'm winning. So it also allows the judge to sort of broadcast to you that you've you have it. And I also, for really weird things that witnesses did, we had an officer once who, it was a drug investigation, and they searched the car and they seized a bunch of stuff from the car, including a bag full of bras. And it's actually a judge asked the question, but it inspired me. And now I use this phrase all the time. Why on earth did you, when they did something so ridiculous that you've already ruled out every possible, good explanation for it, why on earth did you do that? And they can't answer it. When you are ready to ask that question, you know that they can't answer it other than to say, I messed up. Yeah, use the open-ended questions when it's clear that there's no way out. I often use them when I've pinned them to, what they know about their charter obligations, that they violated those charter obligations, that they're not trained to do it that way, that they're familiar with the rules around, 10A or 10B or Section 9 or whatever. And then I ask an open-ended question, say, do you feel you violated my client's charter rights in this case? And a crown will be up out of their chair, and then you can point them to that Ontario Court of Appeal case that says their knowledge of violating the rights is relevant to a 24-2 analysis. And the judge goes, well, it's fine. And then they answer the question. And always they start listing off all the sections of the charter they breached. It's really weird. They just become really willing to admit they violated the rights. Police also love to have their own little in-house expert witnesses. We deal with this obviously with impaireds. We got the DRE officers. There's the RCMP lab rats that do all of the blood and alcohol analysis. And then of course you deal with other police experts like fingerprint and DNA, and they're all the expert witnesses, but they're all in that role because they're boring and they have no personalities. They don't, you're not a patrol officer who goes and becomes a fingerprint expert if you're super exciting and interesting and you can deal with the public. So you have more you put on more personality than the witness to compensate when you're crossing those police experts. And I pretend like I know nothing. I pretend like I am the dumbest person on the planet. This is the first time I've heard about fingerprints. Can you believe it? Nobody ever told me about them before in my life. And the experts, because this is all they do and all they talk about, they actually kind of get this weird sense of feeling like they want to educate you. And it's usually an infantilization thing about women too, where they don't think that you're very smart, and so they kind of get at ease, and then you can catch them off guard because you actually are going to know more than they know about their topic if you prepared correctly. And then all of a sudden you can say, oh, so if this is this way, then this must be the case. And then you've confronted them with something that they can't disagree with at that point, because they're taken aback that you know more, and they don't really know how to respond, so they just agree with you. And the more they speak, the more they're going to educate you about their area of expertise, because they believe that they're teaching you, and they're going to be willing to say things that they don't even realize are weaknesses in their case. I cross-examined a fingerprint expert once, and I had him talking all about how the prints could probably not have been from my client by the end of the cross-examination, because of where the substrate was on the outside. It was boring stuff, but he was like, oh yeah, and that's because of this, and he was so excited. He thought he was teaching me, but actually he was just undermining the case. Golden rules for cops: don't ask questions unless you already know the answers or the answer couldn't hurt you. Be nice. I like to say, structure each theme of your cross-examination like a pin, narrow it down to the pinpoint, and pit police witnesses against each other. Because they usually read each other's material, you can cross-examine them on what's in the other officers' reports. And you can cross-examine them if you know Officer Smith operated the breathalyzer wrong, and Officer Davis is coming to testify about something else, but he's also a breathalyzer operator. I will ask Officer Davis 15, 20 questions about how the breathalyzer works, get him to confirm all of the things about how it works, just to ask Officer Smith all the things he did wrong to confirm that he did them all wrong. And then I say to the judge, look, we have Officer Davis, who knows how this works, who's trained, and then Officer Smith says he did everything the opposite way. It's obviously not correct. And you pit them against each other. They don't even know it's happening, and their evidence ends up being unreliable. Obviously, reaffirm your favorable facts from direct, and anything that's omitted. This is especially important as in impaireds, because a lot of people will rely on he didn't say there was slurred speech, so there was no slurred speech. I get them to say there was no slurred speech. You didn't put in your notes there was slurred speech. You didn't put in your report to Crown that there was slurred speech. It's not in your administrative suspension report that there was slurred speech. There was not slurred speech. Like, I do that for every symptom to eliminate all of the symptoms, to minimize the indicia of impairment. And so each omitted fact I'm going to use as something that didn't happen, because I know as well that if they all go, well, actually, no, I suddenly remember there was slurred speech. Great, now I'm going to impeach you. So it's also something that I find helpful. And there's my last slide. It says, buy my book. Okay. All right. We have 5 minutes left. Oh, I see questions in the chat. Okay, Natasha, you've probably been reading the chat, so I'll.
I was and I wasn't. I stopped. I did that same thing that you did, Kyla, with the fingerprints with DNA. I played dumb. Like, how does that work? Well, then, if it's on blood, can it be transferred to this thing or the other thing? And basically admitted that it was transferred substance. I don't really see any questions.
No,
So
and
that's-
if anyone has a question that they want to ask live, they can ask you ladies. They don't have to necessarily just type it in the chat.
Yeah, I see more like commentary or thoughts in the chats.
Great.
So I actually have a question. So yeah, I tend to do that whole I suggest to you, I'm going to put to you. And so are we just saying, because I saw Anita answered, so you can just say, like, let's say you're saying, I'm going to put to you that, I don't know, you were actually in a different room when this happened. So would you just say, like, do you see what I mean? Like, I don't know how else to say it.
Right.
Oh.
You just do it like that. You weren't in the bedroom, you were in the kitchen.
Oh, but then so then you just say that as a statement.
Yeah.
And then
Or isn't that right?
Okay, so you ask that sort of at the end just so that it seems like a question.
Exactly. And then there's obviously you've got something to impeach them on. Either something you said previously, what you explained that the layout was like this and not like that. We know the attack happened in the bedroom, therefore, and then you go back through it. But yeah, I think there's way more power. I agree with Kyla completely. I avoid all of those. There's way more power with just, you were in the kitchen, not the bedroom.
Okay.
And Nadia made a good point in the chat that, like, when you're using those statement style questions, get the witness in the rhythm with the, is that right? Is that correct first? And then once you've got that rhythm going, you can just drop that because you're already in the pattern, and the judge is into the rhythm too. And they won't even notice that you didn't go, is that right? And nobody will stand up and go, that's not a question.
Yeah, they're getting entrenched into the pattern. It's the other thing, don't rush the cross-examinations. I know judges are, especially in OCJ trials, are like, go, go, go. This is supposed to be a one-day matter. We've got to get it done. But take the time you need to set up that banter, and set up that flow. If it takes an hour, or it takes an hour and a half, or 2 hours or 3, that's what it takes. But at the same time, I've seen some junior counsel do this where they ask a lot of questions at the front end that don't really help, right? About maybe policies or procedures or their understanding of the charter, or spending too much time on that, where if you do that too much that in the front end, you're losing your audience, who is your judge as well.
We do have a question. They're asking, do you have any advice for preparing cross for witnesses that gave very brief or bare bones statements? Good question.
I usually will emphasize with them that they knew it was important at the time that they were giving their statement, that they knew that, the police were probably investigating a criminal offense, that it could be used in court, that they knew it was important to tell all the truth, that they knew it was important to tell all the details that they could remember at the time, that all the details that were important they needed to give to the police. And that usually keeps them from expanding too much from the statement.
I agree. That's exactly what I do. How about a runaway witness? Also a witness who won't shut up.
That's in an upcoming session.
Yeah, that's coming, ladies, we promise.
And there's one question from Anita. Actually, she's asking you, Kyla, the rare but effective open-ended question thing, trying this when they say they did something and what they did was stupid. Is it risky to just say why? I do that sometimes with great effect. It's similar to why on earth, but used at a different stage of things. your why is a little incredulous. If you know what I mean, what do you think? So she's asking.
Yes, I think why is very, very risky. And I only will ever throw in a why when I've thought through that no matter what they could say to justify this, it's not going to help them. That's the only time I will ask a why, which is why usually my why is an incredulous why, because why? But yeah, I be very careful about why. Don't pull out a why unless you know it's gonna go your way.
It could bite you. There's one, if there's a complainant for a minor assault and they start their statement to the police with, I will only talk to you about yesterday because if I say too much, he'll be in too much trouble. Then says there was nothing ever physical before yesterday. How do I impeach? Oof. I'll only talk about yesterday because if I say too much, he'll be in too much trouble. I think I think the impeachment value is in the fact that she refused to talk about it, right? And there was nothing physical before yesterday. I think that's the impeachment value. I mean, that's kind of, if that's what she's saying, that's kind of all over the place. I think you'd know more about it once you get in there. I'm not sure about your thoughts, Kyla, but it's like because there's different kinds of trouble. Trouble doesn't have to, the crowd's gonna like that. Oh, what else did he do to you criminally before? But trouble could be he'll get evicted, or they'll take his dog away, or his credit card payments will be overdue. Like trouble could be anything. So I think that's how you have to handle it.
And I think I would have a long conversation with the client about what it might be.
Fair. Yeah. What is she talking about? We want to know what that is. Because there's some things you don't want to ask your client before trial, but that's one of those things you want to know.
Might be. Yeah.
Yeah.
The 24-2 case, I don't remember the citation off the top of my head, so I will have to email it out. I'm sorry. But I will find it and email it. It's in my long list of really great case law.
And Kyla, you will also provide your PowerPoint presentation,
yes.
Right?
Yes. So everyone will get my PowerPoint, which reminds me, this is probably a good time to say who is going to get a book. And I am just going to pick a name that appears on the screen. Brianna Stats. Congratulations, you have won this book.
Yay.
Don't forget to take a group photo. You know I'm obsessed. For my Twitter, WiCCD's Twitter demands a group photo where everyone who's able.
Okay. So I will unpin you ladies.
Oh, we can do that in Zoom?
Yeah.
Oh, learn something new.
Okay. Anita, are you going to be taking the photo?
Yes, I'm very expert at taking the photo.
Yeah.
I will not appear in the photo because I look like hell, but I was gonna make up some lie and then I didn't have anything. I figured I'd be caught in it by you people anyway. Okay, so if everyone is ready, okay, perfect. I've closed my chat where I was saying how the cops would be beside themselves if they were flies on the wall to us. Scheming. Yes, if they were here. Okay, people are still pouring in. Okay. All right. So we're going to say 1, 2, 3 contemporaneously. 1, 2, 3.
Contemporaneously.
And everybody knows what it means. Okay, I'm going to take a second one. You can say 1, 2, 3 at the same time. For those in the back. Okay, perfect. Beautiful. Thank you so much. What a great looking bunch. That was really fantastic, everyone. And that's just the first of 4.
Glad you guys found it useful.
Thank you very much. And Natasha and Kyla will be back on June 1st for session number 2. And I think that's going to be on impeachment, actually.
And if you don't win the book, I say buy the book. I have the book. I use the book. It's a really good book. And I'm a really good cross-examiner. And I've learned a lot tonight and from the book. So I recommend the book. It's brilliant. Thank you so much, everyone. What a great session.
Great night, ladies. Thank you.
Bye-bye.
Bye.
Good night.